welcome to the Legal Eagle. Our guest on the show is one of Bombay's best-known lawyers. He's former Advocate General of Maharashtra. He's done his LLM at Harvard. He's also someone who's brilliant, extremely pleasant, and also someone who's been known to have been extremely erudite when he comes to his word. I welcome on the show Mr. Darius Khambata. Mr. Darius Khambata, thank you for being on the Legal Eagle. I know you're extremely private and you very rarely make TV appearances. So thank you, sir, for being with us. Your first years, of course, you were an excellent student at Government Law College in Mumbai, after which you went on to Harvard. In between that, you did a lot of moot court competitions. Take us through those early formative years that nurtured you, that nourished you, and what was your experience in those years like, sir?
I think it was great fun, and certainly more fun than I see youngsters of today having. Perhaps because we had more free time and we were under less stress. Mooting was great fun. I always loved debating and I loved the moot courts. And I think that's what first kindled my passion for the law. So we had a lot of mooting. My second year, I think, won the Bar Council of India moot court competition. It was the first or second year of its institution. And then a friend of mine, Amit Haryani, and I also represented India at the Philip Jessup. And I think we did quite well. We ranked in the top 5, if I'm not mistaken. So that really sparked my interest in having a good debate, which is what you need to be interested in if you want to become an arguing lawyer. But you also have to learn, as we do in practice, that you respect your opponent's point of view, you try not to interrupt him, and you try to have the judge reach a just and fair conclusion.
I want to first go on to your early formative years. You've done your school, you've done your college at Government Law College, you've been an excellent student there. You went on to practice and do your master's at Harvard Law School. In between, you did your mooting. Take us through those early formative years, please. What nourished you, what nurtured you, and what were your early formative years like, sir?
I think those years were a lot of fun, actually, and far less stress than I see youngsters going through today. It was actually as competitive. I don't think the competition was excluded, but it was, for some reason, we had more time, and we could pursue things like mooting and debating, which I've always loved. So I loved the mooting. I think that was what first sparked my interest in becoming a litigator, an arguing counsel. And it was my second year, I think, that I won the Bar Council of India moot court competition, individually and as a team.
Mr. Khambata, this is also, we are talking about 1980s, at a time when this was sans mobile phones. It was a time when it was a slower life. You went to Harvard at a time very few people got an opportunity to study abroad. What were those years at Harvard like? Was it a completely different lifestyle for you? Was it a completely different change for you? Take us through how it impacted your legal acumen, and also what the lifestyle there at Harvard was and how different was it from India?
So it was a master's degree, a one-year course, very intensive. And I think it was that year abroad that finally set my course to join the bar. It's an amazing law school. I'm sure the other great law schools are also very good. But this was an amazing law school because they taught through the Socratic method, which is to say, they didn't teach you from A to Z. They threw problems at you, issues at you, theories at you, and made you think, made you argue with yourself, with others in the classroom. You'd be dunked with about 200 pages of course material for every class, which you were expected to go through. I won't say read. You had to learn the art of going through a mass of material, making your notes and trying to reach the core of it, which is effectively what we do today when we read our briefs. And then you were encouraged to think out of the box. You were effectively taught that there is often not one right answer to a legal problem. There are many ways of approaching it. And I must admit the first 2 or 3 weeks were very disconcerting because I obviously come from a system where you had to learn in a particular sequential way. You were spoon-fed in class. You had what Americans disparagingly call horn books, which were ready-made commentaries. We had none of that at Harvard. We were like thrown into the deep end, and we were warned that you will feel very confused and lost in the first 2 or 3 weeks. But things will suddenly fall into place, rather like a jigsaw puzzle. That's the example they gave, and I think it was a very apt example. And when they do fall into place, they'll make much more sense than had you learnt them in a traditional way. And that was right. Within a month, you were really there on top of the game like everyone else was. They had open book exams, which are far more difficult than the closed book learn by rote exams. I think the toughest examination I've ever done was an 8-hour take-home paper in constitutional law, and we were taught by the great Larry Tribe, who you may have heard about, a great American constitutional lawyer. Fantastic class. So I always encourage youngsters to go abroad, not only because they get a different style of teaching, though now the national law schools in India are excellent. They teach in much the same way, and therefore you already have that backing. But you're living in a different culture, in a different system, different society. That itself is the learning.
So that's an interesting piece of information, sir. Very interesting. Sir, I also want to come back to now. You came back to India. You joined one of the most illustrious chambers at that time, Sir Jamshedji Kanga's chamber, after which you joined Senior Advocate Mr. Iqbal Changa's chamber. You said once that it was a very protective environment that you were in. I would like to know a little bit about that. And of course, very interestingly, the Indian Express cases, the legendary team of lawyers you were a part of. It was Ram Jethmalani, Fali Nariman, Iqbal Chagla, Guru Murthy, yourself. This was the 2 years we've often heard of, but I would love an elaboration about what those exciting times were like, because it was one of the first cases that we as law students and journalists had heard and researched much about.
Okay, so let me start with my chambers. I was very fortunate to have joined Sir Jamshedji Kanga's chambers. He had, of course, long expired by then. He died in 1969. But his spirit, I think, just lived on in those chambers. Everyone spoke about him so warmly. I don't think I've heard a senior in the profession being spoken about as warmly and affectionately as I've heard Jamshedji being spoken about. I had a great senior myself, Iqbal Chagla. He was the ideal senior. You couldn't ask for more. We had Kharseji Bhaba, who was his senior, who was also a family friend. He, in his turn, his juniors had been, amongst others, Fali Nariman, Iqbal Chagla, Soli Sorabji, and others. So he had a very illustrious career, and he was a great fun to be with. I had a great band of juniors with me. Many of them were far senior to me, but they sort of tended to look after me as the young puppy in chambers. And it was almost like a club atmosphere. You felt like going there. Often not much work got done. It was more fun and play than work, but that, I think, helped build the bonds and helped secure you from what is quite a tough system as a junior when you go to the bar. It's a ruthless system. You often don't get credit for work you do, yet every mistake you made, it's like in a goldfish bowl. The whole world knows about it. So it's a tough system. You need that cocooning, and I think you still need that cocooning today. And I try to act the same way with my juniors as my senior did with me, which is to say, complete irreverence of your senior. No sir, no obsequious language, nothing like that. They have to. The Bombay bar, we have this tradition that you call anyone at the bar by their first name or by their surname, regardless of his seniority. And you encourage that. And I think my juniors, I've been fortunate to have a wonderful set of juniors myself. We've had great fun in chambers, and they've had great fun at my expense as well, I must confess. In those early years, the Indian Express case, the ANZ Grinley's case, these were my early cases, the Patel engineering case. All of these give you opportunities, which you have to seize as a junior. You have to slog, of course. A junior's role is to slog. And we had to do a lot of work. We didn't have the tools that juniors have today. Research was far more difficult, but in the end, far more rewarding in those days, because when you found authorities, you found a line of argument, you did it after a much greater struggle than you do today. And I think it had that much more value to it. You had none of the other tools like mobile phones, email, internet. Even the PC was new. Most people didn't have personal computers. Laptops were not even dreamt of at that stage. So It was tough, but it was rewarding. You learned a lot. And in the Indian Express matter, you mentioned some of the seniors. We also had Ghulam Vanvati, P. Chidambaram, and Arun Jaitley. I struck up a friendship with Arun, a very warm friendship from those days. He was, of course, much senior to me. He was like a very paternalistic person. And I used to love those walks at the end of the day in what was then, of course, Madras, now Chennai. But we would have a walk in the evening, and he would share his experiences, which were vast by then. And he really gave of himself. Ghulam Vanvati as well, very open and shared a lot of experiences. And of course, all of these were top-class lawyers. So you learned a lot, even of the law, apart from everything else.
That's lovely to hear, sir, because I remember when I used to meet Mr. Jaitley earlier, he used to always talk about those days, and he used to say that this was something that had left an impressionable mark on him. So it's great to hear about a case that was almost landmark. Mr. Khambata, I also wanted to ask you now, you've been Additional Solicitor General for 3 years in the state of Maharashtra. You've been Advocate General for a period of 2 years. You were an important part of the Adarsh team at the time when the Adarsh case was being fought. You once said that government law officers should be serving the constitution. I do see, when I see law officers, whether at the centre or at state level, very few think like this. What could your message to law officers be, and how do you think, what was your time in government service like?
The funny part is that I think I succeeded more in cases for the government because I didn't identify with the government. So it's because the court always felt that I was taking an independent line that I think the government got the benefit of the doubt in several cases. And you have to be independent of any client, and more so when it's the government, because when you're appearing for the state, whether it's the state or the union, you're actually appearing for the Union of India or the state of Maharashtra. You're not appearing for that particular government. That's the idea of having constitutional offices. So it's very important to make that distinction for yourself. It helps you in your legal thinking. You then focus on the case. You give, I think, better representation to the government.
Mr. Khambata, you have served as the Vice President of the London Court of International Arbitration, as well as currently member of the Court of Singapore International Arbitration Centre. Sir, as a journalist who's been covering courts, we've often seen delays, whether it's the Nirbhaya case where we saw a delay of 8 years, and you've extremely passionately spoken about saving judicial time. You're extremely meticulous, one of the very few Indian lawyers who's a success at international arbitration. How can India and Indian courts save judicial time? One of the very interesting, fascinating suggestions that has come from you is put the arguments on paper. Can you please take us through certain things that could help Indian courts, Indian lawyers to save judicial time?
Our judges across the board, I think, are doing a fantastic job. I mean, one cannot imagine how hard they have to work and what they have to juggle and what they have to do to try and dispose of matters, to do justice in case after case. It's almost superhuman. So you have to tip your hat to them 100%. And I feel we lawyers have not done enough to assist them in that task. Of course, we need more judges. Of course, we need more infrastructure. That's a no-brainer. No one can dispute that. But the question I always ask is, until that happens, do we throw up our hands and say, well, nothing else can work, and until we get more judges, the system is going to go along as it is? And I think no. I think it's our duty to actually work more efficiently because we have fewer judges. And we've got to give them the assistance they deserve. So I've always felt that, and of course it depends on the type of matter, but if it's a matter where a point is being decided or a final hearing, it assists the judge if you give your arguments in advance in writing. Now, it doesn't just assist the judge because he's going to read them. It assists the judge because when you yourself put down your arguments in writing and you know they're going to be scrutinized by the other side and by the judge, there is an element of self-censorship. You prune all the arguments which are really untenable, unsustainable. You cut to the chase, you come down to the core, you try to think of what the other side is going to come up with, so you try and preempt that, or you avoid points that you know ultimately won't work. And the other side does the same thing. And if you exchange those submissions in advance, there's less ambushing of your opponent, which is a practice that has grown in Indian courts, which I don't think is a good practice. And what I mean by ambushing is that all of us, and I hold myself guilty as well, please don't exclude me, we thrive in a system where we keep our arguments close to our chest and don't disclose the line of argument or the authorities we are going to rely on until the last possible moment. And I think that doesn't serve the system at all, because you want to win a case with a good legal argument and an answer to your opponent's argument. You don't want to win it because you haven't given your opponent enough time to think about the case you've cited, and you swung it past him sort of without there being adequate. But that's not the way to win a case, and that doesn't serve the ends of justice. So it focuses a matter from all sides if you file written submissions in advance. And I'm happy to say that one of the positive aspects of the COVID pandemic is that more and more lawyers are now doing this, because it's easier to argue virtually if you have a written note before the judge. If you condense, you have to disclose your authorities in advance because you can't physically hand them across the bar. You have to file them in advance. And I think that's helped the system, and I hope these sort of things remain even when we go back to full physical functioning. So in India, I would think if a judge asks counsel for a reasonable time estimate and then broadly persuades the counsel to stick to that estimate, and of course, by persuasion, a judge has many weapons in his armory, and that persuasion can get quite insistent and ultimately tough if necessary. But if that happens, I think you will cut down a lot on arrears. The other thing I believe in is sometimes it's probably easier to finally dispose of a matter rather than hear an umpteen number of interim applications. Because even when you argue interim applications, it's a cardinal principle of law that you have to satisfy the court that you have a prima facie case, which means you end up arguing the main matter, maybe 70 or 80% of it, just for an interim application. And this might happen in a series of interim applications in the same matter before different judges. It might have just made more sense to say, fine, I'm giving you all a fixed time schedule, file pleadings, file submissions, and we will dispose of the matter finally, perhaps even out of turn. You'd be surprised at how taking a matter out of turn actually expedites it, because very often defendants feel that if they take up all sorts of objections, they have a long innings to play before the moment of reckoning comes. But if you advance the moment of reckoning and say, well, day after tomorrow or next week or next month, matters get settled.
Sir, I want to ask you now about freedom of speech, about where you think India is headed, and how you think freedom of speech in today's India is being looked at.
So that's a huge canvas you're asking me to paint on. So I really, I've always believed truly that a vibrant democracy cannot survive without freedom of speech. And what I mean by a vibrant democracy is also a democracy which values and encourages entrepreneurship, free enterprise, creativity, both scientific and artistic. Ultimately, all of these are linked to a system that allows you space for freedom of thought and expression. Of course, freedom of speech and expression is misused by so many. You have so many cases of hate speech and other misuses. But any good system will have its vices, will have people misusing it. The misuse of it should not lead you to throw out the baby with the bathwater. Because if you do that, and if you develop a system where people are not enthusiastic about expressing themselves, then I think you lose on various aspects. You lose on creativity, certainly. At every stage, political parties of all hues have not liked criticism of government. But when they are in the opposition, freedom of speech becomes a big issue. When they are in power, freedom of speech is not so important. As the great K.M. Munshi had said in the Constituent Assembly debates when they were discussing whether to include sedition as one of the permissible restrictions on free speech, and thankfully they did not. He said the essence of democracy is criticism of government. You can't have a vibrant democracy unless you criticize, and criticism should not be seen as an us or them situation. It should be seen as something positive. Equally, I do believe as citizens it's our duty to praise and not only to criticize. I think we have one huge advantage, and that is that inherently we come from a culture and a civilization that has been tolerant and accepts different points of view over millennia. I mean, take the example of my own community, the Parsis. We have been in India for over 1,000 years. I don't think in any other country we would have been allowed to maintain our own identity over 1,000 years. And I think that has to be attributed to the wisdom and tolerance and all accepting nature of Hinduism. I think one has to say it because I think this is so important. And it would be a shame if that sort of open, tolerant, inclusive approach was somehow diluted in any way.
Mr. Khambata, I am at loss of words because of the passion with which you spoke. I am extremely touched with what you said, and I completely agree with you. It's India's civilization that has to be always preserved, and I completely am in agreement with what you've said when it comes to preserving our rich culture. I ask you something then, sir. You could have also contributed. You've twice been offered to be a part of the judiciary. You've twice politely refused. With such ideas, with the conscientiousness which I just saw in your earlier answer, very few lawyers would actually take out time to write their pleadings. Very few lawyers would talk with the zeal that you have about India, the passion, the love, I would say, that you have for our country. Why would you not want to be a part of the judiciary and be able to advise people on how they should be able to go forward?
You know, that's a very difficult question. And even to this day, I sometimes put myself into a bit of turmoil thinking about that decision. Maybe at sometimes I do regret it. I really deeply respected the two Chief Justices who asked me. Coincidentally, both were from Delhi, actually. And the first he was really kind, and he asked me at a time where he told me that he had checked the All India list and I would be the junior most by about 6 to 8 months, which obviously in our system means you have a good chance of rising up to the Supreme Court. And he was very persuasive. He enlisted the help of the then sitting Supreme Court judge who knew me. And I was actually very close to accepting. Perhaps I should have. But I didn't, and I have to live with that decision and move forward. But I think there are also other ways in which you can help the public interest.
Mr. Khambata, of course, I want to ask you a question that many want to know. How do you maintain a work-life balance? What are your hobbies? I do know, like I said earlier, that you're extremely fond of history and Western classical music. You also said that you read more than one book at a time. There are certain sections of history you're passionate about. I would like to know how history is important, and also you've said Western music is something that can be intellectual. Please take us through and make us understand how this can be done, sir.
You know, I think the first thing as lawyers we have to realize is that getting every single brief and taking loads of matters per day should not be an objective. However much you try, you cannot give of your best if you overload yourself with matters. Unfortunately, I don't think I make enough time for reading and music. I should make more time. I know some of my colleagues are far more disciplined in their time management, and I respect them for that. But yeah, for me, reading is important, and music has been a companion for decades, and it does help you. It helps your emotions, your thoughts. It certainly has helped me.
No, I don't think so. I think that's great to hear and something we should all imbibe. My last question then to you, Mr. Khambata. What is your success mantra? Over the last half an hour that I've been speaking with you, I've also come to realize you're extremely conscientious. You're also someone who really truly believes in India's civilization. What is your success mantra? Because you know how to save judicial time very clearly, something that other lawyers should understand. But what would your advice to young lawyers also be, sir?
My advice to young lawyers is be conscious of how lucky you are. You're born into, I believe, the greatest nation on earth at a time which is exciting, where there is opportunity for change. You can make a difference to society. You have far more opportunities than we did. And I think if each citizen in their own way tries to do something good, and look, nobody's perfect. Please don't get me wrong. Sometimes I tend to sound as if I'm sermonizing. I'm not. I make many mistakes. I've not been, everyone makes mistakes. Everyone does the wrong thing once in their lifetimes or more occasions. It's not that anyone's perfect. But at least if you try to do the right thing, I think each individual can make a difference. And the younger you are, the more difference you can make. So I think go forward with optimism. Go forward with a fair approach and an open approach. And I think, as Gandhiji said, you must become the change you want to see. First, you change in the way you want others to change. And that will happen, and the word will spread. The change will hopefully spread.
I think I'm going to end this interview by calling you extremely conscientious and a great lover of India. And for that, we are extremely grateful for having you here on the Legal Eagle. Thank you, sir, for giving us your very precious time and being a part of the Legal Eagle today.
Thank you for having me.